plainly said the city thinks the Supreme Court got it wrong. Despite a unanimous opinion where all 7 justices upheld a lower court's ruling that the city illegally took a developer's land without paying for it, the city wants the court to reconsider its ruling, and now other jurisdictions are joining the fight. Why are they saying they want to keep paying for this?
Because they voted for it. They got us into this mess, and I presume that they believe that they weren't wrong, even though 3 judges said they were wrong. So now here we are today at the taxpayers' expense.
With the exception of Councilman Cedric Creer,
I don't think the city did anything wrong.
Every other candidate for mayor has publicly said it's past time to end the Badlands battle and settle the remaining lawsuits with developer Johan Lowy, whose EHB companies own the defunct golf course near Alta and Rampart. There are 4 cases involving different land parcels on the Badlands property. Despite residential zoning, the city's elected leaders prevented Lowy from developing homes on his property by repeatedly denying permits, which they did against the advice of their own staff and planning commission. Every court has sided with the developer, calling the city's actions an illegal taking without just compensation. It's leaving taxpayers on the hook for nearly $240 million so far. As 13 Investigates reported, the city is beginning the next fiscal year in the red after setting aside $60 million to satisfy the Supreme Court's decision, which involves just one of the 4 disputed parcels. We spoke to Jim Levitt, one of Lowy's lawyers, after the Supreme Court's April ruling.
I think the most important part of this decision is it definitively defines what property rights landowners have in the state of Nevada.
But on May 20th, the city filed this petition asking the Supreme Court to change its decision, claiming justices overlooked, misapprehended, and disregarded controlling authority and material facts, adding the opinion has widespread serious consequences for the city and the entire legal framework for master planning. Last week, Clark County and the cities of Henderson, Boulder City, and Mesquite added their voices, filing what's called a friend of the court brief, writing if rehearing is not granted, it'll not only result in the overpayment of compensation by the city for the taking, but also impact the valuation of property in other takings cases. The county and municipalities believe the court was prevented from hearing all the relevant evidence regarding the land's value, and they claim the court abused its discretion by not allowing the city to cross-examine the landowner's expert appraiser. Jim Levitt says that's simply not true, and that the city was given the opportunity to depose the appraiser, but didn't do it. The Supreme Court opinion reinforces that, adding that the city agreed to introduce the appraisal report in district court and failed to hire its own expert appraiser despite multiple opportunities to do so. Does something smell here?
I'm going to leave that up for the judges to decide.
The county's brief asks the Supreme Court to hold the purchase price a landowner paid as always admissible in eminent domain cases. In a Thursday statement, Levitt wrote, "This serves only to harm and prejudice Nevada citizens. If a homeowner purchases their property in 1994 for $100,000, and then the government takes that property 30 years later in 2024 when it's worth $1 million, the government will introduce the original purchase price in an attempt to drive the value down and get the property for pennies on the dollar in violation of the Constitution." The Nevada Supreme Court properly rejected this troubling government argument in its opinion, and it's disturbing. The county is pushing for a ruling that would severely harm Nevada landowners. The developer's attorneys say the city's petition for rehearing is nothing more than re-argument of issues the city lost at the Supreme Court and every district court over the past 7 years. They say there's no reason for the Supreme Court to rehear or reconsider their opinion, calling the city's petition just another delay tactic. The court has not yet ruled on whether they will rehear the case. Darcy Spears, 13 Investigates.